Now, on 105.9 FM and streaming worldwide on the WMAL app. O'Connor and Company.
6:36. It's O'Connor and Company. Thanks for tuning in here on this Thursday morning with a special. I haven't made enough ballyhoo of the fact that we have a special command performance from Julie Gunlock, who's rarely here on a Thursday. But look at you, putting in for 4 days this week. My goodness, you are.
Can't get rid of me.
Now, this is the kind of leader an army demands. And we appreciate you leading by example. Coming up at 8:05, KT McFarland will be here. And then at 8:35, Diana Mayhew from the Cherry Blossom Festival. Today's the first day of the Cherry Blossom Festival. First day of March Madness. First day of spring. That's all I got. I'm sure it's the first day of other things, too. Joining us right now is Professor Donald Kochan. Now, the professor is at George Mason University. You guys in the bracket? Are you doing March Madness with George Mason? I don't remember if you guys made it to the 64.
The men's have not, but the women did well this year.
Oh, well, there you go. All right. So the ladies of George Mason will be doing well in the tournament, and then there you go. Thank you. And he is, by the way, a director of the Law and Economics Center at the Antonin Scalia Law School. So I got to ask you about it. This must be really interesting for you as a law professor, especially at a school that carries the mantle of Antonin Scalia, to sort of see this play out right now between the federal courts and the Trump administration. We keep hearing that there's a violation of the separation of powers when it comes to Trump pushing back on the courts, but it goes both ways. The separation of powers, you could also make a case that judges are overstepping the separation of powers by meddling in the executive branch, yes?
I think that ultimately there is a large amount of discretion in the executive to administer the laws and administer the agencies before them, and as a consequence, that needs to be respected, including deciding to exercise their discretion to choose not to regulate. And I think that that's what you really see playing out.
Yeah.
And what you also have to recognize is that there is there in the separation of powers, there needs to be a respect for Congress, which has given this delegated authority to the executive branch in many cases, and also given the executive branch the capacity to decide when and how to implement the congressional commands. Too often that gets lost in the process, is that Congress is not actually dictating the outcomes of the regulatory decisions. They're just giving the space for the executive to decide how to balance that regulatory authority.
And that's indisputable. I mean, we've seen this over the years where Congress will pass a law, and then somehow over the years we'll have all this sort of accretions happen within the administrative state where that law that was passed 40 years ago is now interpreted in such a way that maybe that original Congress never even imagined. Title IX is a perfect example of that, where now, under the Biden administration, the protection of women includes men who present as women, right? And I don't want to drag you into all of that, but it sort of is something that we've been grappling with. It's like, where exactly does this work if an administration chooses not to do that? We've seen administrations over the years and these agencies sort of extrapolate onto these laws, but what happens, as we're seeing now, a perfect example is the EPA, where the EPA is refusing to administer these very robust and some would call out-of-control regulations. If an agency like EPA has the freedom and the ability to build on existing legislation, do they also have the ability to pull back and say, no, we're not going to spend this $20 billion that the Biden administration earmarked. We're choosing not to regulate. If it goes one direction, Professor, why can't it go in the other?
Well, and in fact, the direction that it's going now is the more appropriate direction. That is, it is choosing when to exercise the authority that Congress has given it first. But second, it is defining the authority in the limited way that Congress intended it to be defined. That is that, you can't presume that these gaps in legislative statements actually are holes in which to drive through a bunch of policy preferences that Congress has not actually expressed.
So
there's also Sure, go ahead.
Well, I was going to say we have a district judge now, Tanya Chutkin, who our listeners are familiar with her name. She was involved in a lot of the January 6th prosecution. She was also involved in the special investigation of Donald Trump's classified documents, I believe. She's now demanding that the EPA spend money that the EPA doesn't want to spend. How can a judge do that?
Not normally. I mean, they can enforce. There are places in which someone who believes they have a contractual right can, in fact, sue the government. But in that particular case, there is the question: if that happens, if this is people who received a grant who believe that they have a contract, then they can sue in the federal court of claims. There's an express venue for those kinds of determinations. But separately. These are the grant programs are not meant to establish contracts, and Congress knows when to use the word shall or to grant things directly themselves, and that's not what is going on here. This is Congress allowing the executive to have the authority to determine when and if to grant things, and also to determine the terms of those grants, and also to determine compliance with the terms of those grants. And so what you see is that playing out, and is sort of a return to oversight and accountability, even in the grant program, and responsibility in determining what the actual dictates of the congressional commands are.
So in this case in particular, where Kochan has jumped in, this is $20 billion that was legislated through the climate bill. I love that they're now calling it a climate bill. At the time, they called it the Inflation Reduction Act. But this was money that was earmarked and legislated. And now the new EPA, 2.5, 3 years later, comes in and says, yeah, well, we don't need this anymore. Has this ever been adjudicated up to the Supreme Court? Has this ever actually been confronted where an agency has refused to spend the money that Congress has allocated?
Yes, there are cases in which Congress has chosen not to take the authority or choose to spend the money that Congress has allocated. And the courts consistently say that unless Congress makes it a non-discretionary command, using the words like shall issue, and in this case, shall issue to these particular people, right, which isn't what's in this legislation, it is giving the executive the opportunity to choose to give these grants, but that is not a command from Congress that they must give them, and it's certainly not a command that they must give them to specific entities. Much of the reporting on this is about the somehow Congress has set aside funds for these people. That's simply not the case.
I love it when we have a guest who actually makes all of us smarter by the end of the interview than when it starts. It rarely happens here, especially when we have guests like Sean Spicer, where we're actually a little stupider at the end. But, Professor, you have brought it, and I appreciate it. I actually know more about this topic than we did when we started. So thank you, sir. Your students are very lucky.
Thanks for having me on.
That's Professor Donald Kochan, energy law expert and director of Law and Economics Center at George Mason's Antonin Scalia Law School. It's 6:44.